Hello, my name is Laura MacInnis. I use she, her pronouns, and I stand on Ohlone land. I am a senior staff attorney at Family Violence Law Center, a small nonprofit domestic violence agency that provides legal and non-legal services to survivors of intimate partner violence in Alameda County, California. I've been litigating family law cases since I became licensed to practice law in 2016, and I have experience representing and assisting self-represented litigants in hundreds of cases. In my experience in the family law system, one of the biggest challenges I've seen survivors of violence face is biased and arbitrary judges who make inappropriate and incorrect credibility determinations about clients based on myths or misunderstandings about intimate partner violence. There's an expression that goes, "A good lawyer knows the law, a great lawyer knows the judge." Without an easy fix to such a looming problem of judicial bias, I firmly believe that much of the challenge could be mitigated with adequately funding legal representation of survivors of violence. Unfortunately, a vast majority of clients I still see walk into court unrepresented. I myself don't have the capacity to even assist with every client's legal concerns, much less represent them in court. But when clients are represented, especially by domestic violence agencies, judges are forced to pay closer attention. One example that illustrates the importance of attorney advocacy that will never leave me involves a client I had who was harassed by a man in a country in Central America when she used to live there. She was later abducted by this man there, taken to a hotel, held hostage for several days, raped, assaulted, and impregnated with her now 5-year-old daughter. When the client and her family later fled to the United States, this man followed her, tracked her down in several different states. She was forced to relocate several times just to avoid his harassment. He eventually found her in California and filed a custody action and was granted weekly visitation with their daughter. After this, the client came to our agency and asked for help. When I filed a restraining order on her behalf and for the protection of her daughter, for her rapist's constant harassment and threatening behaviors, as well as the past history of severe violence, the judge and the mediator made clear in our first hearing that they did not believe the client's account of what happened, and they believed their relationship to be consensual. After this hearing, I gathered at least 4 witnesses, some evidence, and an expert witness to litigate the case. This case was set for trial, and I eventually negotiated a 5-year restraining order and restricted visits to supervised visits only. Without an attorney for this client, I truly believe her rapist would have obtained more and more visitation rights and maybe eventually joint custody because the judge simply doubted her story. This is a story that is familiar to almost every attorney I know who practices family law. It is not uncommon for litigants who told a consistent narrative of abuse to be denied protection because the judge didn't believe them or their motives. With more specialized attorneys behind clients who are facing high stakes like loss of their homes, children, finances, and protection, judges will more often be educated about domestic violence and will be more challenged in court. More attorneys will lead to more oversight, will lead to more favorable law for judges to be required to follow. We've made enormous progress in this arena, and so much of it relies on funding. However, we are still vastly underfunded, and we need to prioritize front and center this issue as it resonates directly to the children and their families' safety and stability. Thank you.